Welcome back to The Explainer. Today we're unpacking a really fascinating legal puzzle from our source article. It maps out this hypothetical but entirely grounded scenario set in May 2026. We're talking about a situation where a single court ruling alters the entire American medical landscape, literally overnight. So let's look at the exact legal architecture that could actually make this happen.
Okay, let's dive right into this. The source presents a highly specific, kind of staggering premise. Picture this. It's late on a Friday afternoon, and 3 federal judges sitting in New Orleans sign a single piece of paper. By the very next morning, 25% of the U.S. abortion supply line is just completely cut off. Nationwide, the article outlines how this action halts mail-order mifepristone everywhere. And we mean everywhere, even in states like California and New York where it's fully legal. It's a massive demonstration of structural legal power.
To understand how just 3 judges could wield that much power, here's our roadmap. We'll go through the Friday night order, the winners and losers, the legal workaround, the 4-step playbook, courts versus agencies, and finish up with what happens next.
All right, Section 1, the Friday night order. We're setting the scene on that hypothetical Friday, May 1st, 2026, when the Fifth Circuit issues a unanimous panel decision. The core of this order is a freeze on something known as a REMS. You can think of a REMS, or Risk Evaluation and Mitigation Strategy, as essentially the FDA's ultimate rule book for a specific drug. Now, for decades, the FDA required mifepristone to be dispensed in person. But as the source explains, back in 2023, the FDA updated this rulebook to permanently allow telehealth prescriptions and mail-order dispensing. And that specific 2023 rule update is exactly what the Fifth Circuit places on ice in this scenario.
The real-world stakes of freezing that rule are absolutely massive. Just looking at the data, roughly 1 in 4 abortions in the U.S., 27% during the first half of 2025, relied on the exact telehealth access that this court order just halted. So while the majority of procedures do remain in person, freezing that 27% overnight represents a huge sudden shock to how healthcare is delivered across the country.
So what does this actually look like on the ground? The article highlights this incredibly specific number, 14,770. That's the estimated number of women per month living in restricted access states who, as of mid-2025, were relying on doctors in so-called shield states to legally mail them medication. With just one ruling, that vital workaround is completely shut down. Moving right along to Section 2, Winners and Losers.
Shifting our focus from the abstract legal theory to the immediate human and market impact, the source details a wide range of heavily affected groups. Obviously, the most immediate hit is to patients in rural areas and ban states, but the article really emphasizes a critical secondary effect here, and that's miscarriage patients. The standard of care for an early miscarriage is the exact same medication regimen. Without it, patients are facing emergency room visits that average around $700. The fallout also hits shield state doctors, certified pharmacies suddenly stuck with completely frozen inventory, the FDA's broader scientific authority, and drug makers who literally lose a massive distribution channel overnight.
Now on the flip side, the source identifies some clear victors in this scenario. This includes conservative legal nonprofits like the Alliance Defending Freedom and political figures like Louisiana Attorney General Liz Murrill. The Fifth Circuit panel judges themselves secure a major ideological win. Anti-abortion organizations finally get the national restriction they've been seeking since Roe was overturned. Interestingly, the source also points out a somewhat paradoxical consequence. Blue state brick-and-mortar clinics, quote-unquote, win a massive surge of patients, though realistically it's a flood they're probably going to struggle to triage.
Which brings us to Section 3, the legal workaround. You might be wondering, how exactly do 3 appellate judges in New Orleans exert binding influence over a clinic in, say, California? Well, the source explains this through a clever, highly technical legal maneuver. See, in a 2025 case called Trump versus CASA, the Supreme Court severely limited what are called universal injunctions. That means a single judge isn't supposed to be able to block a federal program for the whole country anymore. To bypass this, the Fifth Circuit uses Section 705 of the Administrative Procedure Act to issue a stay instead. A stay simply postpones the effective date of an agency rule, and since an FDA rule applies everywhere, postponing it automatically impacts the entire nation. It's the exact same effect, just wearing a different legal label.
But here's the catch. Before you can issue a stay, you have to prove you actually have the right to sue. In the legal world, that's called standing. The source details how legal architects iterated their strategy after facing a defeat at the Supreme Court in 2024. They shifted from using uninjured doctors as plaintiffs to using the state of Louisiana. The state argues a downstream financial injury, basically saying that complications from mailed pills eventually cost the state Medicaid dollars in ER visits.
It's a really novel path to secure standing, and the panel buys it.
Section 4. The Four-Step Playbook.
The author asserts that this single ruling is absolutely not a random occurrence. It's the result of a highly coordinated, repeatable strategy. Let's walk through the blueprint. Step 1. Identify a federal executive branch regulation you want to dismantle. Step 2. Find a plaintiff with arguable standing, like a state claiming a financial burden. Step 3. Pick a friendly venue and appellate circuit, deliberately choosing where you're most likely to win. And Step 4. Secure that nationwide APA stay. The source actually issues a stark warning here. This exact pipeline is poised to be used next against environmental protections, educational policies, and labor regulations.
All right, Part 5, Courts versus Agencies.
Stepping back from this specific case for a second, we can really see how this was made possible by a massive shift in American administrative law. For decades, starting back in 1984 with a concept called Chevron deference, courts generally deferred to the expertise of federal agencies when regulations were challenged. But in 2024, the Supreme Court's Loper-Bright decision shifted that immense power right back to the courts. This hypothetical 2026 ruling is basically the ultimate real-world test of that shift. 3 judges with absolutely no medical background substituting their own scientific judgment to overrule a 24-year-old FDA approval.
The source really contrasts the court's action with the actual underlying data. The drug has a very long safety record, 36 associated deaths out of over 5 million prescriptions across 24 years. To put that into perspective, the source notes that regular over-the-counter Tylenol kills more people in a single year. Plus, the market structure itself is fragile. It's a $1.1 billion industry, but it's dominated by small private companies. That makes it highly vulnerable to judicial pressure since there are no massive pharma giants to fight back in court.
Because of this huge discrepancy between the safety data, the market realities, and the court's ruling, the source article frames the situation using these exact words. That is not a court doing law. That is a court doing policy. The author impartially points out that this ruling operates way less as a medical safety measure and much more as a deliberate workaround by the judicial branch to achieve a political ban that the legislative branches haven't actually passed.
And finally, Section 6. What happens next? This whole narrative leaves a massive, unresolved tension hanging over the entire American legal system. The explainer concludes with this really urgent, provocative question. What will Justice Samuel Alito and the Supreme Court's shadow docket do with the emergency appeal? Will they let the stay stand and allow 3 judges to rewrite national health policy? Or will they rein in this unprecedented test of judicial power over federal agencies? It's a cliffhanger that really forces us to question the balance of power in modern government and just how durable the procedural rights we take for granted actually are. Thanks so much for joining me for this deep dive. Keep questioning, keep learning, and I'll see you next time.